have our distances.
Friendly conversation.
Thank you. Too many now.
Yes, too many.
Shall we start? Good morning, everyone. My name is Kishore, and I'm a founder and managing director of Caveat Capital. We do legal funding, litigation finance. Today in this panel, I'm a moderator, and we're going to talk about litigation for corporate litigation, and we talk about high-profile cases and how we learn lessons from the corporate litigations. Corporate litigations, or say, let's say dispute, are not only the dispute, but it's all about safeguarding the image, reputation, risk management, and managing internal control, and how to learn from the other big cases, and making the company risk averse and mitigate the risk. Today we have a very good gentleman, two gentlemen, very well experienced about those, and they will talk about this. And let me introduce them. We have our first speaker, Mr. Ziad Salloum. Ziad Salloum is a managing director and managing partner of Salloum and Partners, LLC. Ziad Salloum is award-winning legal advisor and arbitrator. Ziad is on the board of many corporates and platforms. Ziad is a Chartered Institute of Arbitrator and on the role of arbitration in the Abu Dhabi International Arbitration Center. Ziad is also a professional associate with Outer Temple Chambers in London. Our next speaker is Mr. Varun K. Chopra. He's from India. He's a managing partner for his own legal firm, which is VKC Law in India. Mr. Varun is a well-known practicing lawyer, and he is a lawyer before Supreme Court of India. Mr. Varun is a member of many many councils, which includes Bar Council in Dubai, Delhi, Bar Council in Delhi, Delhi High Court, Bar Association. He's a member of Competition Appellate Tribunal Bar Association. He's a member of International Bar Association, International Council of Jurists, and he gives training as a moderator by Supreme Court of India. He has more than 10 years of experience in civil and corporate litigations, and he's going to give you a lot of example of cases he has come across. It's going to be a rich experience. So have a round of applause for this in welcoming these two gentlemen, please.
Thank you.
Thank you. Okay, Ziad, please.
Morning. Yeah. Where would you like us to start?
Yeah, please go ahead on talking about your experience in corporate litigations and lessons.
Oof, where would you start? I'm going to try, I guess, not to kind of dwell on legal details. I think you're all lawyers. You know how the stuff works, but more on some of the more practical aspects of kind of getting through all this stuff. So I've been practicing here in the UAE now for about just under 20 years. In a former life, I was in banking. I was in capital markets and then private banking, and then converted to law. So my approach to the law has always been a bit wonky, different, you might say, right? And then that sometimes helps with working or providing practical advice to clients or working with them on a practical basis. And but mostly my practice has been focused on arbitration. But I've also now started covering a significant amount of litigation work as well. Anyway, just naturally, right? So one of the biggest takeaways, I guess, if we're going to be kind of focusing on generalities for a moment, is going to be the the importance in this part of the world of being a sort of a bridge between cultures and civilizations. You have a significant number of people who come in from abroad and set up or have problems, let's say, and they either come from a common law background, and then they don't understand how the civil law system locally ends up working. So you end up having to do that sort of bridge across. But that sort of change in perspective, or the differences in perspective, can actually be extremely rewarding, because some of the hardest cases we've ever worked on as a firm have been when we were working or assigned to work with foreign law firms, common law lawyers. And it was getting them to kind of understand how the legal system here works and addressing their questions and getting every single thing that we would provide tested to the core. And they would always say, well, give me jurisprudence. Where did you get this from? Can you explain more? Can you get me more information? And the deep dive that allows you to do is quite extraordinary. You end up, as a practicing lawyer, understanding your own legal system significantly better as a result of it. You maybe hate it in the process. It does take a lot of time, a lot of research, but it's extremely rewarding ultimately. So that sort of deep dive can be very, very useful, I think, to get started. Varun, I don't know if you have a couple of thoughts to kind of...
No, I completely agree. See, firstly, thank you, Kishore, for the beautiful introduction. I must say it was impeccable. So thank you for that introduction. And see, corporate litigation and high-profile cases in India, they have stepped up. And as the law is innovating in India, there is a lot of development. And that development helps the foreign investments to actually come into India and look at from that perspective what the government, what the Supreme Court or the tribunals are intending to look at. Because India being a developing country, they cannot have legal impediments or judgments or laws which will actually create or impede any investment which is coming to India. So that's why the judgments which are recently coming upon in India have been very, very innovative and have been to the extent of promoting investment in India. So what I would like to share with everybody here is some of these high-profile cases which have actually turned the scenario and the investment sector in India through these judgments. For example, one could be a classic case of Vodafone, that is from the income tax prospects. The second could be of corporate governance, which is the fight which happened in India, and it turned around the entire concept of operation and mismanagement, Tata Sons. The third could be from the antitrust point of view, which is the Competition Commission of India. That is a Kingfisher case. That's also a classic case. Then fourth could be, which will interest everybody here, is NN Global. And that's a constitutional 7-judges Supreme Court judgment. And I happen to argue that matter as well before the Supreme Court. So that was a very critical judgment which came, and we often call it NN Global 2. So I'm just going to highlight those aspects. Yes.
Good. So, okay, let's start with the first one, let's say for Vodafone, if you like.
So, just as a classic example of Vodafone, most people must be aware, there was a huge battle which happened in India when Vodafone, just to give you a broad prospects of facts, there was a Vodafone Group PLC via Vodafone International Holding, Netherlands and Hong Kong. They had an offshore agreement for taking over 67% of stakes in 2007. This was completely an offshore transaction. However, they had assets in India which related, this offshore transaction related to the assets which were based in India. So the income tax department, which is very, very dynamic in India, they came up with a notice to the Vodafone saying this offshore transaction which you have done is liable to tax in India, and that tax wasn't small. That tax ran into at least $25 million or probably more at that point in time. This battle went up to the Supreme Court. There was actually a concept of, or a doctrine which was evolved at that point in time. That was the look-through doctrine, which was established by the Income Tax Department, and they said that you have to look through the transaction and see the assets are underlying in India, and that's why it is taxable, although the law never permitted that. And the issues, accordingly, the issues which came up before the Honorable Supreme Court at that point in time was, does transfer of shares between two foreign companies result in extinction of majority stake in Indian company held by a foreign company? That was one. Can transfer of shares between two foreign companies be considered as a transfer of capital assets? That was two. Is such transaction, the above two transactions, are they taxable in Indian jurisdiction? So the Supreme Court came heavily on the Income Tax Department and said that the law per se does not permit you to uphold or to imply the look-through doctrine. And that law is, and it is a completely offshore transaction and not taxable in India. But as you know, Indian government and Indian tax department are very, very innovative. They came back with the law. They came back, they enacted a law with its retrospective effect, and they imposed the demand again on Vodafone. That matter went on into arbitration, and Vodafone again, of course, succeeded. But by 2020-21, that tax was actually rolled back. So what do we learn from this? The primary learning which in my opinion comes to me is that there has to be a clear understanding of the transaction, the predictability of the tax in order to invite foreign investment has to be very, very crystal clear at the time of making a particular transaction between the parties. The second would be the arbitrary changes or the legislative changes, assuming in this case had happened, which happened because the income tax came out with a retrospective law. That should always be challenged, because on the basis of first principles of litigation, those laws which are coming back with retrospective effect per se would be unconstitutional to the country which is coming up with such laws. So they have to be looked into and challenged so that you can succeed. That is what I have understood from such laws. All over to you, Kishore.
Thank you. Good insight from the Vodafone case. So it's about learning well before your liability, your risk exposure, and be prepared for that.
Correct.
Exactly. Okay. There's another topic we can discuss about that, the corporate reputation. When there are cases, whether small or big, corporate reputation is always on the risk. I'll give an example. Johnson & Johnson, everyone knows about this company, and everyone knows about the situation when then Johnson & Johnson has to face the legal case. And there was a rumor about, it's one of the product, which is talcum powder, and the rumor about that using talcum powder can cause cancer. So here, what Johnson & Johnson has done is they become highly transparent, highly informative to all the public, and they made sure that how to manage this. Once they become transparent, once the communication went well to all the media public, then people are more aware that this is nothing but a rumor. There's no cancer. So they have, see, through the transparency and proper communication, they have managed their reputation well. So, Ziad, you have any references about reputation management?
Yeah.
Or risk mitigation, let's say?
I think risk mitigations in that context is extremely important. We've had, but the transparency kind of is culturally, let's say, in this part of the world, not the first thing. It's not the go-to. So people tend to be extremely private. They do not or prefer not to be in the news, not to have their details, kind of their dirty laundry out in public. So you tend to find that there's that discomfort that comes along with that. I mean, no one likes to be in the limelight for the wrong reasons, especially. So, well, we did have a recent case where I did anticipate that there is a significant reputational risk. Mm-hmm. It had to do with some shares, a company that was listed abroad with a series of corporate structures in another foreign country with majority ownership or significant chunk of ownership coming from this part of the world, and the management team coming from this part of the world as well, with one of the shareholders who at the very, very top level, who is somebody who is quite high profile, put it that way. So, at the beginning, I figured, okay, this could blow up out of proportion, especially since there was a dispute among the shareholders. Tried to get a reputational management company put into place to try and assist with this in case something were to happen. Obviously, there was a bit of reticence to kind of go down that road, and then ultimately there were some publications made that came out in print in some of the foreign newspapers about some of what was happening, because there were some improprieties, let's say, at the corporate governance level. It's not always easy to manage those things. As long as you're upfront and you anticipate the risks, see them coming, you can put in a plan to try and mitigate those as you go.
Yeah.
But you have to acknowledge that there's very little that you can actually control going into this stuff. And a lot of it is going to be, how do you manage your client throughout that process? Because the moment something blows up and goes, they'll forget everything you told them.
Proactiveness.
Yes, it's all about it, almost like you have to become a psychologist a little bit, right? You have to kind of manage them through that process, and anticipate them kind of getting extremely upset when things kind of go the way you anticipated and you told them about. Right, that worst case sort of scenario, managing that process through. It's not an easy one, but transparency is the ideal solution.
Yes.
If you have that option.
Transparency, proper internal controls, corporate governance, compliances. These are the key points where every big corporates can focus on to mitigate the risk.
But if they come to you with a problem, typically, you're not in a position where you can affect or put in those sorts of changes, right? Especially if the issue at hand is a corporate governance issue. If it's one like the example you provided, where the issue is something external, and then the good governance structures that are in place come in to help out to kind of mitigate the reputational risk among others, that works. But if like in this instance, the dispute was among the shareholders to do with breaches of various agreements amongst themselves and fights among who's going to be controlling, the breakdown in corporate governance has already happened, right? And there's not much you can do about that. Yeah, by that point, you kind of have to. This is where maybe there's a divergence in risk in interests. Sometimes people kind of lose sight of the fact that this is a corporate entity which has its own interest at stake, and the infighting amongst shareholders will affect the company at the end of the day.
Absolutely.
Which means that if the company sinks, nobody wins, right? So it's getting everybody to kind of focus around one central point, and usually when people are fighting, they don't want to hear that, right?
It also actually crumbles the investor's confidence.
Correct.
Which is very, very crucial, and that's what happened in the second case which I had mentioned to you, which was Tata Sons. I'll talk about it after.
Go ahead.
So it's a classic example. It's a classic example of what we were just speaking right now of corporate governance. Tata's, everybody's is globally renowned, is one of the biggest conglomerates in India, and spans over thousands of crores and millions of dollars. So Tata Mistry case, how we all know about it, it came in 2021. Just to give you a brief fact, there was Mr. Cyrus Mistry, who was the then Tata Sons chairman in 2012, and he was removed in 2016 due to loss of board confidence. Then Mr. Tata, now he's no more, he requested for his resignation. However, Mr. Mistry refused that he will not resign from the post of the chairman. And then they had a board voting, which went into 7 out of 9. Directors voted for his removal. However, he challenged that, and Tata Sons cited that it is trust and confidence deficit flowing from previous events, and that is why Mr. Mistry challenged it in NCLT on the grounds of mismanagement, operation and mismanagement. And now operation and mismanagement is duly defined under the Companies Act, and of course various jurisdictions would have their intricate details of operation mismanagement, but the basic understanding of operation is excessive use of powers being at the board, and mismanagement would mean something which is not being done in the interest of public interest or in the interest of the company. So that is per se the general meaning of operation in mismanagement. Subsequently, this matter went up to NCLT. The NCLT dismissed Mr. Mistri's claim and said there was no operation in mismanagement. So this is the first level. NCLT is National Company Law Tribunal in India. That is the first company court in which you can file petitions on various petitions, including the insolvency bankruptcy court. So he went under the preferred application before the National Company Law Tribunal, and the National Company Law Tribunal, being the first instance, said that futuristic mismanagement or any operation they didn't see at the board when it was 7 out of 9, and they rejected his claim. Thereafter, he went to the appellate stage, which is the NCLAT, that is National Company Law Appellate Tribunal, where Mr. Mistry succeeded in saying, and he was reinstated as the chairman. So I ask myself a question, and I ask everybody this question: does an appellate tribunal have the powers to reinstate someone as a chairman of a board in which is 7 to 9? So that was the drastic thing which NCLAT did at that point in time. And that was challenged by Mr. Tata in the Supreme Court. And he succeeded. Of course, he succeeded. And Supreme Court, in crystal clear words, analyzed and said and ruled that NCLAT cannot interfere in the removal of a chairman unless it is proven oppressive, mismanaged, or prejudicial under 241. What NCLAT did was, they said there was operation of hypothetical future mismanagement. Based on that, he was reinstated. They said that the investor's interest has to be kept in mind. That's why there is futuristic or a hypothetical mismanagement which might happen. Basis that, NCLAT reinstated him, which was very funny. But then what do we learn out of this? We learn what my friend and what Kishore was also saying, is that the highlighted conflicts between the parties have to be managed at the corporate level. Why? Because it actually crumbles the confidence of the investors which are present, which is the backbone or the heart of the corporates. If they go away, then nothing survives. Secondly, like he said, transparent decision making. And in the case of Tata and Mistry, it was clearly held that there was transparent decision making. Why? Because they had a board meeting. It was 7 out of 9. You can't be more transparent than that. And lastly, the importance of corporate governance, what I believe is the corporate governance should not go out of the boardroom. It should be managed then and there. And you have to nip the bud. And if you don't do it, there is a lot of fallout which needs to be protected in-house rather than going out. So these are the small little learnings, but which have a huge impact on the corporate side in India, and has had a lot of corporate impact in India based on these recent judgments, which was in 2021. So I hand over to Kishore.
It looks like in corporate world, there are a lot of enemies around you, and they play a lot of games, and it's all about competition. Okay, let's say in my example, I have given example of Johnson & Johnson, and there was a rumor of cancer, but Johnson & Johnson has to do a lot of things to spend money, time, and awareness and transparency. In your case, what you're saying, that the Tata case, again similar thing, that someone else is creating this on a futuristic basis. It's all hypothetical, has no ground.
Hypothetical.
But they are doing, but they have to face this. So the lessons are like, be always proactive.
Correct.
Be always transparent, regardless of anyone asking any question, regardless of any case is coming up, but you need to be always proactively become transparent and make sure that the internal control are in place. Now I will talk about risk mitigation.
Just to add on the lighter note, Kishore, since you're from India and whoever is from India, we always have a tale. Your best friends are your best enemies. The boardroom is your best friend, and boardroom is your best enemy. In order to succeed, you have to know their loopholes, and then only you can compete and succeed.
We have, like in the corporate world, companies face two phases of competition: in competition, in-house competition, and outside competition.
Correct. They're absolutely outside. Outside competition is no competition for them. In-house competition is the competition.
It's
for
more,
them.
more serious because
More
they know the
serious.
nitty-gritties.
They know the nitty-gritties, they know how to manage the board, they know your loopholes, and sometimes you always say it's best to sleep with the enemy to kill him. Right? So they know everything about it.
Yeah.
So that's why I said risk management,
Yeah.
corporate governance, transparency, it has to be done in the boardroom. As soon as it goes out, you lose your investors' confidence completely.
True.
Completely.
True. Regarding risk mitigation and being proactive, there is one of the aspect which corporates can take is insurance, and I think Mr. Ziad can speak more about.
Yeah, on that, just to carry on with your question, you asked, can the board, sorry, can a court reinstate a member of the board?
Yes.
And you know, there's a very interesting case currently going on in the US as well with a very similar sort of thing. Very high-profile case. I think everyone, or many of you may have heard about this one. It has to do with a shareholder vote of a very large publicly traded company called Tesla.
Yes, yes.
So let's say, imagine the first shareholder vote had issues. There was a second vote that also the same judge decided to throw out, as far as I'm aware. I'm very curious if we have somebody who is familiar with that case, if you could give us their perspective at the end of it. But the question then is, can the judge overturn the shareholder vote there? And I guess the biggest lesson we can take from all of this stuff is if a dispute kind of escalates and goes to the board, to the courts, you don't have the control you think you have, even if you have an excellent case. Even if you have a fantastic case, you are going to be spending a lot of money. It's going to be a lot of time and effort. The only people who end up basically doing well out of it, perhaps, not always, definitely, are the lawyers on both sides if they want to be very, very aggressive and drag this out for a long time, right?
Yeah, that's very interesting. You know, in Tata's matter, what happens is, per se, what I understand of the law and the corporate law across the world, I believe India has also based those corporate laws, analyzing the corporate laws across the world. When you talk about a corporate, it is the board. It is the fulcrum. It is the heart of the corporate.
And then above them, you've got the shareholders.
Above them is the shareholders, etc. But then, does the court have the powers, like you rightly said? In our act, per se, the court doesn't have the powers. However, if the court is using those powers, they have to assign several reasons. Now, in this case, in your Tesla's case, whether that's going to happen or not, time will tell. Yeah. But then, per se, court in India, they cannot. They cannot. We've just been seen. But it'll be interesting to see what happens in the US.
It would be, yeah.
Especially with Tesla.
Yeah. So that's a small aside. So going to the insurance, to answer your question on the insurance side, I think that the core item there for one of the large cases, so we handled a series of cases to do with insurance in the last few years for the same client. And this is where documentation and the importance of documentation, I cannot stress this one enough, right? And it appears over and over and over again in all the, I was trying to think of all the big cases we handled in different fields, in different areas, and it all boils down to the quality of the documents that people have put together. In this part of the world, particularly, evidence has to be document-based primarily, right? You can support something with, let's say, a witness, with some witness evidence, written witness evidence, but it's not going to be, it's not going to carry the same sort of persuasive value as a written document is going to have. So whether it's an email, whether it's WhatsApp, whether it's a letter, it doesn't really matter. But as long as it is a written document, contemporaneous written document from that time. So let's say if you have a large client with a big project, the construction project or other, you will have, the project will basically end at some point in time, maybe with some delay, but then, from the, let's say, the employer side, they're going to put the paperwork aside, the project's done, right? The liability periods are over, they're using the facility, if it's a facility, or they're using the building, whatever it is. So those papers are going to be archived. Right? You need to have a way to retrieve those archives in a timely manner if and when something happens. It becomes a significant problem the larger the organization is. The more difficult it is to get paperwork. People leave, and are replaced by others who have no memory or no recollection of what happened or where the documents are stored or how they're organized. And imagine you have to go through thousands upon thousands upon thousands of papers to get to and identify the ones that are crucial. Regardless of how many documents you've got, ultimately, virtually every single court case or dispute that we've ever worked with will boil down to a handful of documents, 20, 30, 100 at most. You're not going to be dealing with thousands of documents that all of which are relevant. They may be useful, but the core are going to be this small handful of documents. If you don't have those even, what do you do? Right? So we had, I can give you a few examples. One of the biggest is insurance. So we were brought on for this insurance case, $350 million claim. Yeah, massive, right? It was over 5,000 individual claims put together. So each document, each claim was approximately anywhere between 1,000 and 3,000 documents for it. Imagine the number of documents you have to go through to clear each and every single one of these things. And they're all missing. There's just a few here and there. Yeah. So it took us about 6 months of cajoling and working with the client to get, ramp up and get an understanding of where things are. And then you kind of look at, so this is one big lesson, take away from there, is your first focus needs to be on time bars, right? So we knew where the time bar is. Here in the UAE, time bar on insurance cases is 3 years. That's not really a lot of time. Usually you're negotiating with the other side, 1, 2 years pass, you go back and forth, etc. You don't get anywhere, then you bring in the lawyers. You bring us in at that last chunk. So we were brought in, there were maybe 6 months left. 6 months to collect 200,000 papers? Forget it. It wasn't going to happen. If no one, you had a significant number of people who were no longer involved in that project at all. So no one knew where a lot of the papers were. So what do you do? So this is where you make lemonade.
Very good insight.
Ziad, I'm going to ask you on the side, what was your billing hours for that? I'm going to definitely ask you that.
So I have come across several companies when we talk about risk mitigation and be ready for that is, in business, everything is relating to cost optimization, okay, because of competition and many reasons. So implementing risk mitigation strategies and creating a system also have cost. So some of the companies, they say, why should we incur this cost? We've never experienced this kind of problems. So, and when they come to know some problem is coming and some case is coming up, they are paralyzed. They're not prepared for that.
Yep.
And this is what Mr. Ziad is also saying, the documentation and the process it requires to safeguard your interest and reputation and control are not there. Whereas some other companies or other corporates who are either proactive or they have some experience of some cases, they have a regular risk assessment periodically. And they manage, regardless of any issue today or not, but they manage to do the regular assessment. They manage to see what are the weak points and leakages, and they control those things so that they are very proactive of any other cases, or if they have any case going on, how to manage them.
Yeah.
Okay? So another issue I would like to discuss.
Sorry, on that, just two quick comments, right? There's an old Latin saying, right? Se vis pacem para bellum. If you wish for peace, if you seek peace, prepare for war. And the other one is the price of freedom is eternal vigilance. In both those concepts, you've got to have, in this context, you have to have your paperwork. You've got to organize things. You've got to be on time, on the spot, responding accurately, etc. Today, for instance, we have a recent case that we're handling now for a client. Their contract, their scope of work is, let's say, X, and they were with relatively tight deadlines. The project overran, and their scope expanded from the initial X to maybe 4 or 5 times what it was. But they did not, in a timely manner, inform the client of the increase in scope or the consequences of the increase in scope.
Yeah.
By the time they submitted the claim, like 6 months had gone by. and then the relationship with the client went downhill. Right? So the client started applying the contract to the letter, like the question how a client who has not been, or parties where parties themselves have agreed to a contract and then applied completely different terms than what they had actually put down, and then suddenly one of the parties goes, no, now I want to apply the terms to the letter, and go from there. And obviously the relationship kind of deteriorates. So you've got to be collecting your documents, responding on time, and that takes a lot of effort and time.
Sometimes they come near to statute of limitations.
Like in this instance, yes. We're very close to the statute of limitations on this. Yeah. So
and every case has a different statute of limitation on the kind of case it has.
Yes. So that's where you learn to make lemonade out of lemons.
The other thing which we may touch upon in this panel, that corporates, they always want to see that which kind of jurisdiction or body should be included in their agreements, governing laws, jurisdiction. So we have alternative dispute resolution as an option also, which is faster, quicker, and cost-effective.
Well, that's what.
Ziad, what you would like to say on that?
It's not always faster. It's not always better. You're right. That's what it's marketed as. But is it always?
This is what real experience works.
It has certainly some advantages and some disadvantages. And I guess ultimately, whatever system you end up choosing, it has to make sense for both parties involved, not us lawyers, so to speak. We might be familiar with a system, and the other side might be familiar with something else, and what's best for them in that context might be something you're unfamiliar with. You have to take the time out to kind of get a flavor, get a sense for what might be the better place for them to do. But, I mean, you've got corruption on arbitration tribunals. You have some judicial systems that are not ideally placed. I mean, you have all those issues of trust. Ultimately, it boils down to trust between the parties. I don't know, Varun, do you want to?
So, see, I always say this. An arbitration or an agreement is a marriage between the parties.
Yep.
An arbitrator is the shrink by the end of it. The parties go to the arbitrator, which is the shrink, and he tries to resolve your issues. And like he said, there has to be a consent, of course. There has to be a consent between the parties, the arbitrator, once they decide who the arbitrator is to be. Like yesterday we were sitting and we were discussing, there are certain agreements in which they will have not just one, they will have a panel of arbitrators, which is 3 arbitrators. I was discussing with Palash yesterday. He said having 3 arbitrators is a pain. How do you manage them? And 3 arbitrators, if you have that kind of a contract, I will request everybody who is looking into these arbitration contracts, please don't have a panel of arbitrators at all. Because it actually does not expedite your proceedings, it actually delays it. So first catch should be that you have one arbitrator, which is by consent agreed upon. Or like John said the other day, you pull a hat, take out the slip, and then you get an arbitrator. Probably that could be one way of doing it. That is the most transparent way. But these clauses have to be looked into in detail. Now, the jurisdiction aspect. See, a clause may define the jurisdiction, but the ambiguity with regard to the seat and place still subsists. So that aspect has to be looked into at the time and based on those facts of the agreement. And then you can decide upon the jurisdiction.
Great.
Yeah, try and leave nothing to chance. If you have a concern about something specific, address it directly from the get-go in your contract. So if you don't want 3 arbitrators, say it in your contract. If you want a specific seat, say it in your contract. If you feel, don't leave it to chance because, or jurisdictional issues, if you can anticipate what those might be. I mean, ask yourself, who's going to be the party most likely to sue in this case? And what are they most likely going to be pursuing? And then see what the worst case scenario is from there, and then work your way backwards to build it.
Like we all say, ambiguity leads to legal tragedy.
Exactly.
Always remember, never leave any agreement in any ambiguous manner or any loopholes or widened. It has to be crisp, precise, and to the point.
Correct.
And tight, so that there is no loopholes. Any ambiguity, legal tragedy, very good for us as lawyers. It will be fantastic.
Another issue I would like to draw, that how corporate can adopt efficiency and that this is where we talk about the technology. There are so many AI tools or other tools available to do case preparation and e-discovery. So how do you see this is going on, and how make this more efficient in terms of cost?
Sure.
And technology has their own risk as well.
So on this case about the several 100,000 papers, for instance, we ended up using software to help us kind of run through it, but we didn't use AI for that. At that time, AI was not the big thing, right? This was just a couple of years back, just before the rise of AI, so to speak. So we used some of the traditional tools out there on the market. They were pretty useful. Ultimately, we found in subsequent cases that some of the AI tools out there they're not there yet to be able to replace a human. They can certainly assist, and you can see the path to where already they are helping get us to the point where you can be more efficient or more effective, but they can get you there faster.
Yeah.
And if they get you there faster, then obviously the costs are going to go down for the client.
Yeah.
So there's a win-win. You have more time to do other things.
Mm-hmm.
But at the moment, so far, until and unless we've got that AGI moment, right, you're still going to need lawyers, maybe a fewer paralegals, maybe. But it'll be, I think maybe it'll democratize things such that let's say an individual arbitrator, for example, will be able to take on more cases because he has the support of AI tools that can help him kind of manage his caseload faster or better. For small law firms, it may allow you to hit at the same level as the larger firms who have armies of lawyers who come in. Like in those cases we talked about, we were the only firm up against two massive American firms, right? So they would come into meetings with like 10 people, and we just show up with one.
Yeah.
All right. We had and you can hit at that level if you've got the tools that you need.
Yeah.
Right. So AI, I'm sure, will help people get there. Will facilitate things for smaller law firms like ourselves and yours, I imagine.
Just one comment on that. See, AI, of course, will help in mitigating a lot of time for document management, I believe. But at that same point of time, there have to be data protection laws in order to protect that the trust which that corporate is imbibing in that particular law firm or the lawyer. So for that, I understand that in India, data protection laws are coming, and they would always have the concept of AI as well, which will actually help in lawyers and other documenting agencies to adopt AI in order to help and assist in corporate governance, in management of documents, even in case management for that matter. So right now, what one lawyer can do with an AI company today is, of course, sign an NDA. Sign an NDA, that could be a way out, that you get into an NDA with the AI company, which could help in corporate management of those documents and move forward. So that there is some document which will protect the interest of your client, and you can always tell your client, see, I'm using this AI, but in order to protect your confidentiality, I have entered into an NDA with him. And you can make a tripartite also if you want, right? So that would be a small way to move forward in these AI.
Do you think it's practical or possible for smaller firms to put into place specific documentation with, I don't know, OpenAI, for example? I mean,
that may not be possible at all. That may not be possible at all. I am talking about as small law firms or boutique law firms, let's not call it small, boutique law firms. For them, we can not put it in open. You can't do that. But if you have some agencies like the one who was here, they can actually provide you those services, and you can enter into an agreement with them.
Correct, but you don't know what LLM they're using in the background to do their operations. So.
But that's where the NDA comes in. In case they are using any other OpenAI tools, they'll have to inform to us. Yeah. So that is where we'll have to come in. That is, see, I understand there is a limited protection you have, but not complete.
Not complete.
Not complete. Not
See,
complete.
this is kind of an open discussion about AI. We can talk endless, and there are pluses, there are minuses, there are challenges.
Definitely.
One of the example is that which we have been facing a lot of time is that nowadays, if any lawyer go to any client or client comes to lawyer, and client says, I have to draft some agreement, some whatever assignment, and then I have already taken something from the AI, but you just, so 80% work is done, 20% you do, and I'll pay you somewhere near to that. So this is the mentality sometime. Yeah. So, but they don't know that every time they take the details from AI, the last statement always say that you need to consult with the lawyer properly. Yeah.
I am just waiting. I just hope that AI doesn't steps into the shoes of a litigating counsel. I just hope that doesn't happen. Otherwise, we'll be out of job.
Yeah, I mean, this is also one of the questions that small and medium-sized law firms or lawyers are facing struggle because a lot of job can be done by AI and has been performed by AI itself. So they are facing. And you see, last month I was in a conference with Microsoft. They invited me, and then we were talking about, they said, okay, they also have lesson learned on this session that, okay, lawyers who are not using the AI and the techniques, they will be left behind against the other lawyers who are using it. So you have to use it, you have to take benefit, but at the same time, you need to make sure that you are well aware of their drawbacks and their limitations. Because AI today, let's say in the legal world, if you want to use AI, you cannot 100% rely. You still need a legal underwriter or a legal experts to finalize this situation, whether it's a case management or agreement related thing. I know we have few clients in US regarding litigation funding, and in US this is pretty mature business, and there are so many AI-based technologies available there, platform and systems available there. They can give you predictability management. You put the facts about the case, and they can give you the analysis that, okay, you have 80% or 90% probability of winning this case, because they have references of thousands of similar cases, and they can give you facts, they can give you the argument has taken place in those cases, they can give you the details of how some cases, relevant cases relating to this case has been won by. So a lot of best features are there, but again, when we go to legal funding and we go to the biggest funding companies, they say we just look into that. We don't take this as a firm or final decision based on the AI report. We take it as a first prima facie advice, and then we go back to our legal underwriter and the legal expert and make an opinion whether to fund this case or not.
See, Kishore, sorry.
Go ahead.
Yeah, Kishore, just to add a small comment. See, there is a difference between requirement and necessity.
Yeah.
AI might be a requirement, but it is not necessity of law. Let us all understand that. What is the necessity of law? What is the necessity? The necessity is of the client to get proper, correct, and appropriate legal opinion. That is where the bridge a lawyer makes. You may require AI to assist you, but it is not the necessity of the client to or the AI to give your client the best opinion.
I will say, because AI is reducing time, AI is making you getting the data accuracy. So there is a lot of benefits over there. But yes, we need to make sure how we are using and what we are using.
Correct.
And what is relevant for our case.
Correct. Yeah, I think that to an extent, all the doom and gloom around the AI side is perhaps a bit overblown, right? If you think about it, okay, great. Today, as a lawyer, you are facing significant competition from other lawyers, right, for the same sort of business.
Yes.
Right. So you're facing competition. Perhaps eventually you can see it coming from AI in certain aspects. Okay, fine. So what is your differentiator towards your client on, why do they come to you instead of another law firm? Why do they like to deal with you and not somebody else, right? The same concepts are going to apply on this instance. Here, maybe the advantages or the beauty of AI, so to speak, is that it is accessible to everybody, or will be as soon as it hits a certain moment. So, I'm sure you've heard of the more recent news of Deep Search. I forget the name now. I should know this. I was reading about this just yesterday. So, trained on $6 million worth of investment instead of several billions on the other side, and it's about 90% of the way there compared to OpenAI and the others. So
it's trading.
Yeah,
it's for stock trading. Deep Search.
It's an LLM that was developed by some Chinese software engineers, and apparently the software engineering itself is quite surprising. So instead of doing we're not going to go into details, but it does seem to be quite interesting, and it's a fraction of the cost of some of the bigger LLMs out there, right? So eventually things are going to be. It's just going to be a tool in your tool case as a lawyer. The core is going to be the differentiating factor between you and others. What is it that you bring to the table, and how far is AI going to be able to take you compared to others? I wonder. For instance, some of the cases we have won, I don't think an AI, at this point in time at least, would have made that connection. It's the connections between completely disparate fields. Today, I could give you, for that case, M&A dispute. This was a couple of years back, a few years ago. M&A disputes between the purchaser and the seller. The seller basically kind of defrauded the buyer of a company. There was a lot of trust between the buyer and the seller at the beginning, and the paperwork was prepared by the seller. The buyer's lawyers or the buyer did not do a pretty decent job of giving it to people who actually did their work right and kind of went through the paperwork right. So there are a lot of documents in there or clauses in there that basically says, I've looked at everything, I'm taking the company on an as-is basis, I'm very happy with the paperwork, I'm very happy with the data room I was given, everything is hunky-dory, everything is rosy, and it's my problem, basically. So you're a super high bar to kind of get over that. Then the client got hacked. So the client was the buyer. The buyer got hacked, lost all his data, or a significant chunk. The gentleman in question at the top of the company, the buyer's entity, was an older gentleman, and he liked to have everything on paper. So the only stuff left were stacks of paper. That was the only the documentation we had. It was whatever he had printed that was still there and hadn't been shredded, right? So if I'd given you all this and given it to an AI platform to kind of give me the best case assessment of this, you're like, this case is losing. You're going to lose this thing. Okay, so what do you do? Right? So going through the paperwork, and I just see one email from the seller, the seller's assistant, because the seller was the manager of the company at the time. The seller's assistant to the seller. And it was a short email, but it was effectively, let's put it this way. She was using the sort of language you do not expect to see coming from a lady, put it that way. And she was insulting the buyer, or the chairman of the buyer, in very colorful language. Right. At the time, this was a criminalized offense in the UAE, electronic crime, that carried a prison sentence and a potential deportation plus a fine. Right? The laws have changed since in many respects. But, I asked one question. Is she the guy's girlfriend? Are they together? And the chairman said, yes. How did you know? It's like, how? Right? How can, for me, it was, well, in what world would an assistant allow herself to use that sort of language when talking to her boss? Right? So I'm like, okay, great. You have a pressure point right there. Push that button if you need to. Because imagine if your wife or your girlfriend or your spouse ends up in jail for something that has to do with you, what do you think is going to happen to you? Your life is going to be a living hell until you fix it, right? So that button was available for them to press, and eventually they ended up settling without taking that nuclear option, so to speak. But that was there. It's not something you could have maybe found with AI. I don't know.
Just one curious question. Just one very curious question. In case they were in a relationship and that email went, would it still hold criminal liability?
Because it spread.
And if they accept the fact that they are in a relationship still?
It doesn't really matter if they were in a relationship or not.
Okay.
And for the criminal law to have applied,
right.
It was more a pressure point, because if someone you're not very connected with goes into jail, I mean, okay, you're going to not be very happy about it,
right.
But is it going to make a big difference to solve the core problem?
Corporate problem, correct.
The corporate problem.
Okay.
It was more,
more of a pressure point.
Pressure point.
Arm twisting methods of lawyers.
Exactly.
Thank you. We are reaching with the time limit. Lastly, I will say corporate litigations and the cases teaches us how to be ready for the future challenges, lesson learned from them, and how to mitigate the risk, how to keep the internal control, corporate governance in place proactively, and how to react, how to manage reputation. So it's a nice interaction today. Okay, I will ask audience to raise any question if they have. No question?
No comments, no questions?
People want to talk, go for the break.
Please.
Yes, please.
Otherwise, I was saying we were brilliant. Yes.
Actually, AI and the accuracy of AI depends on your input of your case.
Correct.
So AI itself will not be able to give you the right answer unless you feed it with the right information. That's in brief. Thank you.
Thank you, sir.
Do we have any question from the audience?
Agreed. Agreed, sir.
Definitely.
Thank you very much. Please, round of applause for
Thanks,
the
everyone.
It was a pleasure.
speakers.
Thank you.
Thanks, Kishore. Thanks, Varun.
Thank you, panelists. All right, now we'll move forward with the next session on litigation strategies, where we'll discuss mediation and ADR as potential pre-litigation or mid-litigation options for dispute resolution. As a moderator, we have Mr. John Louis, arbitrator and mediator, Louis Arbitration, France. And as our panelists, we have Ayman Al-Ashri, senior legal consultant, Hamdan Al-Shamsi Lawyers and Legal Consultants LLC UAE, Mr. John Louis, arbitrator and mediator, Louis Arbitration, France, Mr. Varun